Good morning, everybody. I hope you're all very well. Welcome to our latest webinar, second of the year. We are live, and I'm Vanessa Bell, and I'm joined today by Matthew Cole.
Morning, everyone.
So after a relatively quiet period over the past year, I guess, in terms of case law and such forth and being preoccupied with COVID, we've actually had quite a few interesting cases coming through. So we thought we would discuss a few of them this morning, but also given the latest changes with regards to the COVID rules, we thought we couldn't really do the webinar without mentioning the learning to live with COVID. Bear with us with that one. So just moving to, if I can manage to click on the slides, mouse is jumping around. Moving to the agenda, I'm going to be looking at fire and rehire this morning and that trend, and explain to you what that means. But most of the time I'll be talking about a case that came through in the High Court last month, which is a really interesting one. And essentially it granted an injunction preventing an employer from firing and then rehiring their employees to push through contractual changes. So I'll be talking about that. Matthew is then going to, whilst we talked about holiday pay cases last month.
You can't get too much of a good thing. So we're going to be talking about it again today. It was one of those weeks, actually, because we talked about the Smith case, and I said it was going to the Court of Appeal, and indeed had been to the Court of Appeal, and the judgment was issued that very week. So we'll be looking at what the Court of Appeal says. Yeah,
absolutely. And you're also looking at vicarious liability.
Yeah, interesting case just on horseplay and employer's liability for a prank that went wrong in the workplace.
What do you say? Employees, your greatest asset, but also your biggest liability.
Your biggest liability.
Yeah, yes. There you go. And then at the end, I'll be talking about learning to live with COVID, what the new rules, or lack of rules, perhaps we should say, may mean for you, and some suggestions as to what I think you should be considering. And then, of course, we will have our Q&A at the end. But as we are live, do submit any questions as we go through, and we'll do our best to answer them.
We will do our best. We were saying earlier we've got quite a small sort of chat window. So if we're squinting at the screen, it's not because we're trying to see through your cameras. It's because we need to see what the question says. So if we look a bit weird, then just bear with us.
Yeah.
A bit weirder.
A bit weirder than normal. Okay. So let's start with fire and rehire. So what do we mean by fire and rehire? So generally with employment contracts, they can only be amended or varied with consent of both parties. One party can't generally impose a change on the other, although of course there are sometimes a little bit of flexibility within a contract, such as mobility clauses. But if you want to make substantial changes, then you need the employee's consent. But one option that is always available to an employer is to actually terminate the contract using a fair process, of course, and then re-engage the employees on the new terms. And this is what has now been bandied around as fire and rehire. Although, of course, employers face the risk of unfair dismissal claims, provided there are sound business reasons and you've consulted with the employees, generally a tribunal will find the dismissal fair, and will find it fair for the potentially fair reason of some other substantial reason. And of course, if the employee does accept the re-engagement, then of course they would have mitigated their losses and the compensation is low. So that is why often that tactic is used.
I think it's fair to say we use it a lot. We advise using it a lot, and normally the ultimatum works.
It does. We don't actually normally get to the fire and rehire point because we've persuaded the employee that actually just accepting the new terms is the best option. But it has come under increasing scrutiny over the past couple of years. And so much so that actually ACAS issued some guidance on it last year, where they kind of were trying to discourage employers from using fire and rehire. There has been talk in Parliament about introducing a bill which would make it more difficult for employers to fire and rehire, which that was proposed by Labour. But at the moment, the Conservatives are quite, it seems, set in their stance that actually they're not going to introduce new legislation to provide additional protection for employees, but encouraging employers to look at the ACAS guidance.
I think it was one of these things, wasn't it? That really COVID
Yes,
and lockdown
was.
sort of led to it being under increasing scrutiny as employers went to change terms and conditions on a more frequent basis, perhaps, and there was a certain sense of scepticism about why they were doing that. Which probably just put it under that spotlight.
Yeah, it did. But what did happen the day of our webinar last month was that we had the High Court judgment through, which marks a new development in this area of law, because actually, as I mentioned before, the High Court in this case granted injunctive relief to the claimants in the case, which actually stopped Tesco from being able to carry out its proposed firing and rehiring exercise. So let's have a look at this case. So essentially, Tesco's proposed to fire and rehire employees who didn't agree to the removal of what was in their contracts, retained pay. So retained pay was a form of wage protection which had been agreed between the union and Tesco's between 2007 and 2009. The background was that at the time Tesco was going through a kind of mass reorganisation programme, which involved some closures in its distribution centres and some relocations, and they were concerned about losing a vast proportion of their employees, and so as an incentive for employees to stay and not kind of accept the redundancy and to relocate, they offered retained pay. Importantly, retained pay was to, they told them that this would provide them with protection for life. It was guaranteed for life, and they were explicitly told that it would remain for as long as they're employed by Tesco in their current role, and it said that their retained pay couldn't be negotiated away by either Tesco's or the union shop stewards. There's a collective agreement which was incorporated in the employment contract, and that provided that retained pay would remain a permanent feature of an individual's contractual eligibility. And these facts are actually, as the High Court commented, pretty extreme. The use and the terminology of permanency and this will be with you forever. But in January 2021, I think Tesco probably looked at their wage bill perhaps, and they formally announced its intention to remove retained pay. As part of its consultation process with the employees, it offered a lump sum payment of 18 months retained pay in return for the employees giving up the entitlement and signing up to new terms and conditions, which would of course exclude the retained pay. The unions applied to the High Court for a declaration that affected employees were subject to an implied term preventing Tesco's from exercising its contractual right to terminate for the purposes of removing this retained pay. And it also sought an injunction preventing Tesco's from terminating the contract. So this went to the High Court, and the High Court granted the relief sought by the claimants. They spent some time looking at the word permanent and actually what the intention of the parties was when they entered into this contract. And they concluded that normally you would consider permanent to be, on the face of it, just a right that would endure for so long as the contract existed. But actually, on the facts of this case, they found that that wasn't actually the intention of the parties, and that the permanency kind of went further than that. And it seemed that they concluded that the objective intention of the parties, as demonstrated by the communications I talked about in the previous slide, was actually to provide a right to which the relevant employees would be entitled for so long as they were employed in the same role at Tesco's. And so therefore, that right would be in conflict with any right to terminate the contract for the purpose of removing that retained pay. So they concluded that on the extreme facts of the case, that it was necessary to imply a term providing that Tesco's right to terminate the contract was noticed couldn't be exercised for the purposes of removing that retained pay. And actually what they did is they looked at permanent health insurance, because of course if employees entitled to permanent health insurance and you don't have that contractual right to terminate employment, then employers face quite a hefty contractual claim, don't they? And they kind of thought, permanent health insurance, well, it's in the title, isn't it, permanent? So they kind of, I suppose, looked at the permanency of the retained pay in that light as well. And so they thought that actually, the very purpose of retained pay would be defeated or frustrated without having an implied term to prevent them from terminating the contract. And therefore, they granted the injunctive relief, preventing them from firing and rehiring. They did emphasise that Tesco remained free to terminate an employee's contract for good cause. So, for example, a genuine redundancy exercise, gross misconduct. But of course, if they're going to do that, I think it'll be under a little bit of scrutiny as to the real intention and motive behind the termination. So what does this mean for us? Well, there's two ways of looking at it, really, doesn't it? I think, the other thing I was going to say on remedies, of course, when you look at injunctive relief, the question that the court has to ask is actually, would damages be an adequate remedy? Because if it isn't an adequate remedy, that's when they give the injunctive relief. And they found that given the significant proportion of the pay involved, which is around 40%, they found that damages wouldn't be enough, particularly because, of course, you have the statutory limits on unfair dismissal claims. So that's why they granted the injunctive relief. So now moving on to implications. So on the one hand, it offers a new means by which employees could challenge employers' attempts to fire and rehire. So perhaps it does increase the risk. But on the other hand, as the High Court's noted, that the facts of this case was very extreme. And by that I mean the intentions being found for the change, for this retained pay to be permanent. And therefore, in reality, I suspect that actually the implications of this case could be limited because of those extreme facts. But as I've said, it does particularly give another tool in an employee's toolbox. Yeah. When faced with a dismissal and re-engagement exercise that's been proposed by an employer.
I suppose the issue is the fact that fire and rehire seems to be falling out of fashion.
It does.
And employers are going to have to consider very carefully how it looks, I think, from an optical point of view and a PR point of view.
Yeah.
I think the reference to PR, the parallel with permanent health insurance, is an interesting one, isn't it? Because it's about, it was Aston Webb's Poultry back in about 2002, 2003. We had that case that said, thou shalt not dismiss if to do so would deny someone their PHI. But actually what happened after that was just an awful lot of judgments testing how far the law went on that. And immediately after, you sort of had a ramping up. But since then, we've had a sort of course sort of saying, well, that wasn't really the intention in much more circumstances, but you can dismiss. Yeah. So I think you're right. I think we'll get lots of challenges, but hopefully the circumstances of those challenges will suggest that we aren't going to be successful.
I've had an interesting case.
It is, yeah. No, it is an interesting case.
Because you don't see injunctive relief that often at all.
No, and I suppose it's one of those other things. If Tesco's could wind back the clock to 2009, 2010, would they be saying this is permanent for life?
Exactly.
That's a very big claim to make to employees, particularly when you're in an organisation which has significant turnover of employees. And the rest of it. So
absolutely. Yeah.
Watch this space.
Indeed. Right. So, Matthew, sorry, I'm just struggling with the mouse today. It's got a life of its own.
Well, I'm going to leave it for you to
yeah, thank you.
So we're going to look at holiday pay, and we're going to look at a case we looked at last time, which was the Smith and Pimlico Plumbers case. And this is a slide we used last time. And for those of you who were on the webinar, then we were looking at the case of Mr. Smith and Pimlico Plumbers, quite a famous case or series of cases actually involving Pimlico Plumbers, because it really all stemmed from this idea of workers and looking at whether or not Mr. Smith, who worked for Pimlico Plumbers from a tax perspective, self-employed basis, and he was a high earner. I think he was earning 140,000, 150,000 a year. Whether he was genuinely self-employed or whether he was a worker with then some limited rights, including crucially the right to paid leave under the working time regulations. And the Supreme Court ultimately established that he was indeed a worker, so he did have these rights. And that led to the holiday pay claim being picked up, and holiday pay was substantial. It's worth about $75,000 on its own, because what had happened was that over a number of years he had accrued holiday pay, or rather he had taken holiday, but he hadn't been paid anything because his contract says no entitlement to pay. And so when it was established that he was indeed a worker and therefore entitled to paid leave, he made the claim for paid leave. And what the Employment Appeal Tribunal said is, well, actually, you're out of time. Unlike an employee or a worker who has not taken any leave, has not exercised his right at all to take leave, which is what happened in the King and Sash Windows case. Unlike that case, Mr. Smith, you were able to take the leave, you just weren't paid for it. And therefore the normal rules of limitation applied, and you couldn't roll over that right from 1 year to another. You couldn't take the accrued amount you couldn't claim for the accrued amount on termination, which is what King and Sash Windows had said. So we were left in this rather odd position where, if you were like Mr. King and you hadn't taken any holiday because you couldn't afford to take the time off, either because you didn't know you had the right or you couldn't afford to be paid, you couldn't afford to take unpaid leave, then you had that claim. If, like Mr. Smith, however, you had taken leave, you just weren't paid for it, then you had no claim. And so, unsurprisingly, it went off to the Court of Appeal. And as I said, the week we were talking about this last time, very busy week in the courts, they issued their judgment in the claim. And they reversed what the Employment Appeal Tribunal had said. And they said that Mr. Smith was entitled to make a claim for his accrued pay, worth, as I said, about £75,000, accrued holiday pay on termination, even though that claim went back several years, and even though had he had the 3-month time limit applied for each of those leave years, then he would have been out of time. But the accrual meant he could claim it. Why did the court say this? Well, they said, and I think they're right on this, we don't see the distinction between Mr. King and Mr. Smith, because the right isn't two rights. It's not a right to time off and a right to pay for that time off. The right is to paid leave. And unless you're getting both the time off and the pay for that time off, then your right is not being adhered to. So there is no real distinction. They went back to what the European Court of Justice had said in King, which was that this is a fundamental right. Working time directions, the Working Time Directive rather, and the working time regulations which come to that, we need to remember as a health and safety measure. And paid leave is seen as a fundamental part of the health and safety framework. It is time away from work. And anything which distracts from that time away from work, anything which deters an employee from taking it, such as the fact that they're not paid for it, means that the right is being breached. And because of the fundamental nature of that, it is right, said the court, that the leave should just, and the right to claim for it should just continue to accrue through the employment relationship. So essentially what that means is if you have an employee or a worker, for whatever reason, who has not been taking or has not been given the right to take paid leave during their employment, and that has lasted over a number of years, it's effectively the termination of their employment or the putting right of the situation. You know, if there is a situation where you say, well, actually, we think you are entitled to this, so we're giving you time, we're giving you paid leave now. It's that which starts the clock on the 3-month time limit, which applies for most employment tribunal claims. So you can store up these claims for many years, and indeed there's a number of claims. You know, we saw it in King, we saw it in Smith, we've seen it in other claims where the amount of accrued paid leave can reach quite high levels, where the employer hasn't recognised that the employee has that leave, you know, because 26 days a year, isn't it? It's 2 months up. It's effective. 28, sorry.
It's 26, right?
I don't know. It's Thursday. 28 days paid leave a year. That's the 4 weeks under the working time directive, and then the other 8 days of bank holidays mounts up. It's effectively an extra month, month per year. So you can end up with some quite chunky figures. And I think what the court says is interesting, and we just need to take account of it. So first of all, we know that the right is being accrued throughout employment, and the claim can be made on termination. Secondly, it's interesting what the court said about paid leave, and I think this is where we may see some further developments. And we know that holiday pay is one of these areas where it's been an incremental increase in rights over many years in terms of precisely what this right looks like, and I think this is significant here. So what they've said is that where you have an employee who has a claim over several years, who has not taken their full entitlement over several years, then there is presumption that that leave has not been lost, and therefore can be claimed on termination. And the tribunal was sort of saying that because of the fundamental nature of the right. And as I said, it's a presumption that the employee has not lost that right. That's a rebuttable presumption, so it's one the employer can overcome. But it's quite interesting what the court says, and I put the quote up there. The employer can meet the burden of showing it specifically and transparently gave the opportunity to take paid annual leave, encourage the worker to take paid annual leave, and inform the worker the right would be lost at the end of the leave year. If the employer cannot meet that burden, the right does not lapse, but carried over and accumulates until termination of the contract, at which point the worker is entitled to a payment in respect of the untaken leave. So let's just look at the requirements there on the employer. It's for the employer to show that they gave the employee the opportunity to take that leave, and they informed the worker that if they did not use it, they would lose it, and they encouraged the worker to take it. You need to be able to demonstrate all of those things if the right is not to be lost. And I think this is something we need to take seriously, because. And actually, yeah, sorry, could you skip slides? Thank you. So we've got a small technical issue with our mouse by the looks of it. We've got this issue. We know there are situations where we have problematic employers who have denied workers or denied a group of employees the opportunity to take leave for whatever reason. They're going to be hit quite directly by Smith and Pimlico Plus. That's accrued and it will be contained. But what about the rest of us who are trying to do the right things? What about those workers and employees who just don't know they have an entitlement to leave and discover it on termination? Well, they're the ones who again are going to have a right, I think, to claim under Smith. And we should be looking at that now. I think it's not enough to just neglect the right. It's got to be a right which is positively promoted by the employer. So there's that group where there may be some uncertainty about the leave. What about the next one? What about this assiduous employee, the employee who has 28 days leave per year, but really loves their job, doesn't have much life outside work, so just doesn't take the leave? All well and good, great Stackhamovite work ethic. If they can get by on 10 days annual leave a year and they're not interested, then the rest of it, well, why do we need to be concerned? What happens at the end when there's a dispute? The employee who feels they've given their heart and soul to the job and not even taken all their leave each year suddenly finds that they're redundant. And they go to a lawyer, you all know what lawyers are like, and the lawyer said, well, as well as your unfair dismissal claim or whatever other claims you've got, looks like you've got a claim for paid leave. And that employee would have that claim unless we can get to a point where we can show what I put in the previous slide. I won't ask you to skip back. I'll just read it out.
Good.
Which is, can the employer meet the burden of showing it specifically and transparently gave the opportunity to take paid leave, encouraged the worker to take paid leave, and informed the worker the right would be lost at the end of the leave year. So you've got to be able to demonstrate that. And that's perhaps where it gets more difficult. But certainly, I think, look at your holiday policies, look at what your contract says, and make sure that it is that transparent in terms of paid leave, and that all managers know that they should not be turning a blind eye to employees who are taking leave. They've actually got to go and promote it.
Can I pause you there?
Yeah.
So questions come through, and I think it's relevant before we move on to the next point. It says, what happens if the contract states that leave must be taken in the relevant leave year, or otherwise will be lost unless it's been agreed with the business to carry forward? So I guess the question there is, well, if the contract says it, can we just not rely on the contract? Yeah,
and I think contract should say that, and I think it's important that that is in the contract. And certainly one of the things which you would be saying to rebut the presumption is, well, look, we told the employee, they agreed to it, it's in their contract. I think that's where the employee came forward and said, yeah, but
who reads your contract
again? Who reads the contract? I don't think that tribunals don't like that argument from employees as much as anyone else. If the contract's there, I think the employee's meant to read it. But I think, what about those cases where the employee says, I couldn't take the leave because, well, I just had too much work to do and we were understaffed, and I had to get on and just do it. So that's where I think the issues will come out. That you can't actually show that there have been meetings with the employee to say, look, Bob, you've taken 10 days of your leave, you've got 15 days to take, you've got to take it before the end of March. How are we going to work this out?
Next question, which I think is a good question. So thanks, Melissa. So all employees have up-to-date access to the holiday entitlement, and we encourage all staff at the beginning of the year to look ahead and book their holiday.
Yeah.
We also operate a use it or lose it policy. However, we always find a group of people, now this happens everywhere, we always find a group of people who leave it to March to book, and so assuming that the end of the holiday year is March, and we try to obviously accommodate the leave, but these are genuinely declined. Is this still okay?
I think lawyers answer it depends. I think if you were to put that practice before the tribunal would have an awful lot of sympathy for you. And I think they would want to find that the presumption was rebutted. So I think continue with that policy, absolutely. Where I think we are all going to be exposed on this are those cases, as I said, where you've got the employee who it just says, I couldn't take it because of pressure of work, because I had too much work to do and the team was too small. And I think what I would be doing with those employees, because you'll know where the problems are saying, right, actually start of a new holiday year, you've got 28, 30 days, whatever to take. And remember, we are only talking about statutory leave, not any additional contractual leave here. You've got this time to take. Last year, you didn't take it all. I'm sorry you've lost that. This year, we need to make sure you can take it. So don't wait until March to book it. Let's get it in now. And maybe even think about scheduling it in for those employees. That may need some difficult conversations with managers who may say, well, my team is understaffed. But I think that's what needs to happen. And again, employers who have pinch points for whatever reason during the year, whether it's Christmas seasonality, whether it's end of tax year, end of financial year, etc. I think you've got to start building those in from the beginning of the year. So hopefully that sort of gives you an idea. So I think we're saying is, continue that, but we may want to do even a bit more and start to sit down with employees and plan when they're going to be taking their leave. The last question I've got on this is, what about underpayments? Now, we see a lot of holiday pay claims, and very few of them are where an employee has not been able to take holiday at all or has not been paid for it. And we know that a number of the cases that have gone in this area are about underpayment rather than no payment at all. So there's the British Gas case, for example, where the employee said, well, I'm discouraged from taking my holiday because you only pay me my basic, you don't pay me my commission, and my commission is 70% of my wages. And that case was one where the court said, yeah, then you've got to add that commission in. And we've had it with overtime recently, and we've got to a state of play where most overtime is now taken into account in holiday pay calculations, because otherwise an employee can be discouraged from taking it. So are we at risk from an employee now coming back and saying, yeah, I know I took my holiday, I've taken it for the last 10 years, but you haven't paid me the shift allowances and the overtime on top. So my claim under Smith and Pimlico isn't for the whole amount, but it is for that top up. It's that extra 20% holiday pay that I would have got had you taken into account overtime. And because of Smith and Pimlico, I don't lose that claim every year. I continue it, and it continues to accrue. So I'll have all of that now, please, on termination. How's that going to be dealt with after Smith and Pimlico? And it's a difficult one. My instinct is that we're going to see again this attritional approach with cases to arguing this point. But ultimately, I think, given the way it's gone with holiday pay, those underpayments for the length of the underpayment, rather than just in the last holiday year, will be claimable. Don't know if you agree or...
Yeah, it's interesting, isn't it? Because of course at the moment we've got that 2-year stopgap, haven't we?
We have.
But the court team don't like that.
No.
And it keeps being mentioned, doesn't it? So I think we are, at some point, we're going to move away from that. And I think probably the 2-year stopgap at the time it was introduced, because it was Bear Scotland, wasn't it? So 2 years. I think it was because it was new and it was a bit of a shock to employers they, this concept that they have to include everything.
Yeah.
Whereas that's not really the case anymore, is it?
No. And I'm not quite sure, because I haven't worked it through, how Smith and Pimlico sits with that 2-year stopgap either.
No.
So it is going to be an interesting one to see. And actually, one of the things the Court of Appeal have done in the judgment is they've rewritten the relevant working time regulations on the basis of to make it compliant with European law, because we know Brexit's happened, but we still have to look at what European law says in this area, because that's the aid to interpretation, and they don't mention the 2 years. So we will have to see, but it's clearly going to be an issue. So watch this space, but certainly look at your holiday pay practices and look at how you might want to reformulate them. Okay. Right, very quick one really, the next one, on vicarious liability. We comment on these cases as they come up. On one analysis, they're all quite fact specific, I think, but it's always just worth looking at them when they do come up, particularly when it's a Court of Appeal who's considering them. So I just thought I'd have a quick look at this one. And of course, the idea of vicarious liability is, what is an employer liable for in terms of the acts of employees? We all know if an employee gets the job done wrong and damages a customer, etc., then the employer is vicariously liable. But what we've had is a number of cases over the years involving criminality in various forms or other, in particular, where the boundaries of that have been tested in respect of what happens when an employee has committed an act which the employer hasn't approved of, hasn't sanctioned, countenanced, and indeed would regard as damaging. And probably the high watermark of that was the Morrison's case involving the data protection breach, where the employee took a load of data, used a load of data with the purpose of harming Morrison's, and at the Court of Appeal, the Court of Appeal said that Morrison's were vicariously liable regardless of that fact, but the Supreme Court reversed that judgment and said no, Morrison's were not vicariously liable in that case. So that's the sort of, that was the high watermark Court of Appeal on that. But we've now had this case, and I think it shows that there is perhaps now a status quo emerging, which is that an employer will not be liable for everything that an employee does whilst at work, although this case I think could have gone either way. Facts are very straightforward. Mr. Chill worked for a contractor to Tarmac. There was a bit of he worked alongside Tarmac's actual employees, and there was a bit of consternation, conflict between the contractor's employees and the Tarmac employees, because the Tarmac employees thought that Tarmac were trying to move the contractor more in and take their roles. So there was some tension there, which is perhaps relevant. Anyway, they worked side by side in manual work. Mr. Chill turned up for shift one day. Whilst he was bending over close to his ear, one of the Tarmac employees thought it would be a laugh to basically hit with a big hammer a piece of metal that he'd taken into work that day. It wasn't part of the equipment he needed for the job. He gave this a whack. I think he gave it 2 whacks, and the effect of that was to damage Mr. Chill's hearing. It caused him to have tinnitus and a slight hearing loss. So personal injury. To what extent were Tarmac liable for that personal injury? Both the lower court said Tarmac were not vicariously liable for that injury. It wasn't connected enough with the employment to make Tarmac liable. And Mr. Chill went off to the Court of Appeal. Court of Appeal agreed with the lower courts and said Tarmac were not liable. This was not an act which was so associated with the employment as to make Tarmac vicariously liable. And it was just worth looking at the reasons really for that decision, given the fact that it did take place in a work environment and you know could be and during work time. Yeah, absolutely. And what did they say? Well, they looked at this and found the act which caused the injury did not further interest the employer in any way. It wasn't something which was, you know, he wasn't even hitting this thing as part of his job and just waited for Mr. Chill to bend down. It was completely independent of it. Secondly, he brought his own piece of metal to whack, as you do, into the workplace. He wasn't using the equipment. There was no instruction connected with that act from the employer at all. The work environment merely provided an opportunity for the act to be done. They did look closely at this issue of tension between the permanent staff and contract workers, and it was something where they said, well, it could mitigate towards there being vicarious liability. But the evidence they heard suggested that there hadn't been a serious level of conflict. There was no threats of violence. There were no sort of angry incidents. It was just a tension. Which led to this, and I think perhaps their thinking there was that if this could be seen as a manifestation of that tension, then it would much more connected with work and terms and conditions. But they weren't of the view it was in this case. So they took the decision that there was no vicarious liability, and Tarmac were off the hook. So it's just an interesting one to look at, and to look at the fact that the tribunals and the courts rather do seem to be moving this way of finding this vicarious liability where there is no obvious connection between the act and the employer.
Yeah, but you sense a fine line, don't you? And the fact that it's even gone to the Court of Appeal has been... Yes,
exactly. That you're absolutely right. It means there was an arguable case, and it was a case which you know, the Court of Appeal felt should be looked at further. So yeah, it's there's always a boundary.
Yeah, there is.
And I think this is one that was just over, from Tarmac's perspective, the right side of that boundary.
Yeah, but I think that's the right decision.
Yeah. I suspect you'd say harsh but fair.
Yeah, absolutely.
Yeah.
Okay, so living with COVID, shall we move on to that? Wow, the computer lets us move on to that. Here we go. It's like, you know, when you have those that metal thing and you have to do the thing.
Oh yeah.
It's like the buzzer.
Exactly on the,
this is exactly how
exactly
it
on
feels.
point.
Yeah, absolutely. So you know, pretty much no restrictions. So walk in the park for employers, right?
Wherever you want. For employers,
Yeah. Well, not quite, but anyway. So government's announcement, and I'm sure you're all familiar with it, but just put it up in the next couple of slides just to recap where we are. So the legal obligation to self-isolate following a positive test has been removed. obligation for employees to inform employers if they're required to self-isolate has ended, and self-isolation support payments has ended, and routine contract, or I think that should be contact, first typo noticed, that's my fault. Routine contact tracing has ceased, and close contacts no longer required to self-isolate or take those daily lateral flow tests. The removal of isolation requirements has been criticised by numerous unions, unsurprisingly, and they highlighted that actually between January, February, there's been an increase in COVID cases that are work-related, so they're obviously very concerned about it. And they're calling on the government in particular to look at key workers and the impacts that will have on them. Unison has called the decision too far and way too soon, and urged ministers to give guidance to employers to prevent workplaces becoming the super spreader locations. So that's my bit of drama. But there's also 2 disabled campaigners who've also indicated their intention to take legal action against the government about the removal of the self-isolation rules. So that's a bit of a watch this space as to what happens there. So that's obviously already in place. What happens in March? SSP reverts to the pre-pandemic rules. So it's no longer payable from the day one. So SSP, you obviously have those 4 waiting days, don't you? So we go back to having the waiting days for those unable to work because they're sick or self-isolating due to COVID. And also those who are self-isolating due to COVID will no longer be eligible for employment and support allowance. And then from the 1st of April, which I think is really, in my view, the next kind of major step, is that free testing for the general public is going to end, although there is going to be limited free tests for a small number of at-risk groups, and also I think for social care staff. Tests will be made available to purchase in the private sector. No idea as to the cost or the availability, but that's what they've said. And employers are no longer going to be required to explicitly consider COVID-19 in their health and safety risk assessments. We have work safely guidance in place at the moment relating to COVID, and that's going to be replaced with a new set of public health guidance. So what does this mean for employers? Well, a couple of things that have happened. The one is that there's the UK Health Security Agency guidance, COVID-19, people with COVID-19 and their contacts, which was published on 24th of February. It gives some guidance for employers. And so from an employment perspective, it includes guidance that basically, since the most effective way to avoid passing on COVID is to stay at home and avoid contact with other people, it recommends that those testing positive shouldn't attend work. And it suggests that household contacts should work from home if they're able to for up to 10 days, and a natural flow test. But for other contacts of COVID, so that's not a household contact, but you know that you've been in contact with somebody with COVID, then there's no recommendation to stay at home. This guidance is going to be updated on the 1st of April. As I mentioned, we still have the working safely with coronavirus guidance, which has been consistently updated throughout the pandemic. And of course, you may know that there are specific sections for the type of workplace that you are. This has been tweaked, I guess, and it's going to remain until at least the 1st of April, but of course then it looks like it's going to be replaced by something else. And these kind of have the 6 main actions. So for example, for office workers, you know, keep up to date health and safety assessments, turn away people with COVID-19 symptoms, look at your ventilation, look at your cleaning, and, you know, communicate with staff. But none of that really gives us any concrete guidance to follow in respect of employers navigating their way through at the moment. So I put up on here a list of things to consider. I won't necessarily give you all the answers because I think essentially it is going to depend on your work setup, your workplace. So you're going to have to decide for for yourselves really how you're going to manage and mitigate the COVID-19 risks, because of course, you know, there are still risks attached to it. And also throughout all of this, remember that you are under a legal obligation to provide a safe system of work. You are under health and safety duties. So we can't just put COVID in a box and ignore it, even though the self-isolation rules have gone. So we are going to have to, you know, think about, you know, safe systems of work and what you're going to continue to do, or what you might relax in terms of the COVID-19 risk. Clinically vulnerable, extremely vulnerable employees, you know, I think, you know, there's been quite a few in the news, you know, speaking out about their concerns, because I think, you know, they feel, well, that's fine for everybody else, but what about me, who's extremely vulnerable and who's been kept inside and shielding for this time?
Presumably it's going to be a disability discrimination risk and reasonable adjustments issue as well, isn't it?
Yeah, absolutely. So for those you know, who raise concern, it's going to be listening to those concerns and then thinking about any measures that can be put in place for them, because they may not necessarily trust the government strategy. Well, everybody's jabbed now, so you'll be fine. What about those that test positive? Whilst, you know, the requirements now that mean not under a legal obligation to self-isolate, as I've gone through the guidance, that really is still at the moment, up until the 1st of April at least, pointing towards, and this is sensible, actually employees who test positive should remain at home, because of course they do attend the workplace, then of course the risk of spreading massively increases, and then that links back to the clinically vulnerable group, doesn't it? So, you know, what we'll suggest is that you do take steps to prevent positive employees from attending the workplace. Again, mention the duty of care that you have. But of course, you're going to have to inform your employees that that's what you want them to do. And I think the communication here is key. But certainly, I think my advice at the moment is that you do send a communication out to say, if you test positive, please stay at home. What about requirement for continued testing? I think many employers, as part of their kind of you know, risk assessments and looking at health and safety, have said to staff, before you come to the office, please do a lateral flow test. I would, whilst they're still, you know, available and free, I would continue that. We will have to look at what the guidance is from the 1st of April and what the cost is from the 1st of April, because actually, you know, is it reasonable to expect employees to go out and purchase these tests themselves before they attend the workplace? Will you consider providing those tests for them, or do we just remove the suggestion or the request or the requirement, whatever it is you have at the moment, entirely? That for me is a bit of a head scratcher, actually, but I think it is going to depend on the cost of the tests and what the guidance, I think, says at the time.
Yeah, I suppose it's got to go back into the risk assessment overall, isn't it?
Yeah,
to see it as a mitigating factor, but how effective is it as a mitigating factor, given the variability of test results in terms of false positives and false negatives, and as you say, even the ability to be able to get employees to definitely take them.
Yeah, absolutely. And then also about sick pay provisions. Are we going to just follow the SSP in terms of reintroducing the waiting periods? If somebody tests positive, the first 3 days, 4 days?
3 days, I think.
3 days.
I was going to correct you earlier, but
you can get me back with your holiday. So the first 3 days, are they going to, if you don't have this opportunity to pay SSP, at the moment, will you require them to stay at home unpaid for the first 3 days? Will you receive pushback on that, or actually will you say that for the time being we will still pay SSP, but of course you won't be able to claim that back?
Well, and also just in general with sick pay, are you going to give it to employees who seem to be prone to catching COVID?
There are a few, aren't
there? There are some who seem to get it on a frighteningly regular basis.
They do.
But if you've got young folk who go out and live it up of a Friday and Saturday evening, then
do you not still do that, Matthew?
then they're more likely to perhaps get COVID than others. Maybe COVID's going to replace the sort of the Monday morning hangover.
Yeah, true.
As the reason why people are not turning up.
Yeah, but did you not know the Thursday has been the new Friday for years, and that's why they come to work on Friday then?
Yeah, but Wednesday's a new Thursday.
Oh, really?
Yeah.
Wow. I guess.
So,
yeah, maybe. Okay, we digress.
last night. Sorry.
And a final note, and we spoke at length the last webinar about unvaccinated employees. But what are we going to do with them? Are you going to consider treating them differently? I.e., stay away.
Yeah.
Can we treat them differently? And I think and I'm not going to re-go over what we talked about last month, because if you are interested, then you can just ask for a recording of last month. But essentially, if we are treating them differently, we need to be careful as to what the reason is for their unvaccinated status, because if it's linked to a disability or religion or belief, then we open up the door to potential discrimination claims.
We do. Yeah. Although I think, and we probably talked about this last time, didn't we? Those are being held up, I think, as a real sort of shield, which I think employers can be quite bullish with, but carefully bullish with.
Yeah, I agree. And I think, on the basis that the government's saying we can relax all these measures because of the vaccination, the logic follows, doesn't it?
It does. There are clearly going to be challenges around that if you are treating people who have been vaccinated differently from those who are not. Yeah,
absolutely. So that's some considerations, potential next steps. Once you've considered your approach, look at COVID-related policies and procedures, and ensure they reflect the approach you're going to be taking with employees, particularly if tested positive. And as I said, review your sickness absence policy and sick pay provision, just because you don't want to send out a communication that may contradict what you put in the policy. I think we forever seem to have been updating policies, haven't we, over the past year or so. Do continue to look at your risk assessments at the moment. And really, for me, I think the key point out of everything is to communicate with the workforce as to what your expectations are and what your approach is going to be, that you are sensitive to those that have concerns, and that you still do have measures in place. And of course, if an employee tests positive, you don't want them to have attended work for a couple of days, not knowing that actually you wanted them to stay at home.
Absolutely. Do you want a question?
Oh, go on then.
Can you read it, or do you need me to read it for me?
If the employee has exhausted their occupational sick pay and has been off work since the beginning of January with COVID, would we need to extend the sick pay, or are we able to then offer SSP as per the contract? Ooh, juicy one, isn't it? I don't think you're not under any obligation to extend your sick pay just because it's COVID. In terms of the SSP, that in my mind would depend on what your contractual occupational sick pay says, because if it's already deemed to include SSP, then they may well have exhausted their entitlement to SSP.
They might have, well, not since January, because there's us and times today, but SSP lasts for
last night, isn't it?
Fair time, yeah, lasts for a fair amount of time. So if I think if they've got SSP, which is still there for them to take, then you pay them that.
Yeah.
But yeah, I think
they've been off work. Sorry. Yeah.
So I think what we're saying is you treat an employee off with COVID as you would treat any other sick employee.
Yeah.
I suppose the issue for me is what happens if you've got an employee who saying, I've got COVID, but I can come in because I'm not feeling any symptoms.
Yeah.
And we say, no, we don't want people in with COVID. And they've exhausted their sick pay entitlement.
Mm-hmm.
What happens then? That's going to be the question, isn't it?
Because
they would say, well, I'm ready, willing and able to work. And I think we would say, well, you might be ready and willing, but you're not able because you've got COVID. And that's where, back to your point about clear communication, which is we don't want people at work with COVID.
Yeah, and I think it would be a reasonable management instruction at this point in time. And I think certainly up until the 1st of April, when the guidance very clearly states actually those that have tested positive shouldn't be attending work.
Yeah.
Now, if the guidance is amended from the 1st of April to say actually employees, even if they test positive, can now attend work, unless perhaps in specific sectors such as social care, then it's going to be a bit more difficult to
Yeah,
give those instructions.
I think
isn't
it would be, and that's where you're going to be back in your risk assessment,
Yeah, you
aren't
are.
you? And ideally, I think if you're taking a defensive approach to COVID, which I suspect many employers will still want to, then I think you've got to be saying in your risk assessment, COVID is a risk. We mitigate this by keeping out of the workplace employees who have got COVID.
Yeah. Yes.
Then you've got the issue about testing and employees turning their own blind eye to symptoms and things like that.
But it's interesting, isn't it? Because I think you've seen a move now towards employees, particularly in open plan areas, where now if they have a cold, instead of struggling in, they'll say, no, we're going to work from home to avoid passing it on. There is a little bit more of a kind of awareness of, if you have something, let's not go in.
For those of us who are lucky enough to be able to work easily from home.
Well,
the issue is those who can't. I think where we are is presumably many head scratchers to come, and I'm glad you're our resident COVID expert and not me.
Oh dear. Well, it's interesting, isn't it? Because you think there's a huge sigh of relief on one part of, don't need to self-isolate, and this is going to become much more easier and less complicated. But actually, you kind of pause for a minute, you think, okay, well, you've just left it up to us to decide what to do and how to manage the risks ourselves without actually being able to point to firm guidance that says this is what we're meant to be doing.
Yes. Yeah.
So I think it's tricky to navigate at the moment.
Maybe though it's no coincidence that the guidance is changing on the 1st of April. Maybe they're going to say, only joking, continues to apply, April Fool. But I suspect that's optimistic.
Yeah, absolutely. Right, so we have a few more minutes, but we can always overrun if needed. As to any other questions that there may be, but I don't think there are. Just to say then, thank you ever so much for everybody who's joined us this morning. I hope you found it informative and helpful, and hopefully we've answered more questions than created questions, which sometimes us lawyers like to do.
Yeah.
And if when you log off you're able to give us some feedback, any comments, that'd be very gratefully received, because we do read them. And also any topics that you would like covered in future webinars, please do let us know as well.
And we'll try and do one of these again next month.
Yes, we will. Yeah.
Okay. Thanks everyone.
Lovely. Thank you very much. Take care, everybody.